Hello, I'm Chris Williams. I have Asperger syndrome, and I want to talk in this episode of my daily video blogging series about what happens if people with Asperger syndrome come into contact with the police and the criminal justice system here in the United Kingdom. Well, I've got it up on the internet here in front of me. It says that most people with Asperger syndrome and other autistic spectrum disorders are largely unfit to plead in court, and if the court is reasonably satisfied that a crime has occurred, under the Mental Health Act 1983, Section 37, the maximum penalty that the person with Asperger's or any other autistic spectrum disorder can be subjected to is either a hospital order, a guardianship order, or an absolute discharge. So that essentially means if you want to take legal action against someone with if you want to take legal action against someone who's got an autistic spectrum disorder, then you're wasting your time, because they will be deemed as unfit to go through the criminal justice procedure. So the most that they will be given is an absolute discharge. Although, of course, there was that case in Exeter where Nicky Riley, the Asperger sufferer, he was sentenced to life imprisonment under the Terrorist Defences Act. No, he was indoctrinated. Of course, people with Asperger's be indoctrinated into doing crimes which other people want them to do, because he was subjected to the full-on terrorism legislation. No excuses can be made for that, whereas for everyday crimes, most Asperger offences are for minor offences. So indeed it says here that an absolute discharge is the most that someone with Asperger's can get if they have committed a crime in the first place. And of course there are some instances where a Crown Court will become involved if it's a very serious case, but then of course you then have to determine with a psychiatric report if the person is fit to understand the proceedings, and even then it's very likely that it will lead to a hospital order. Because it's well known that there are many thousands of people in the criminal justice system apparently with undiagnosed Asperger syndrome and other autistic spectrum disorders, and the human rights people say that such people should not be in prison to begin with. Now, absolute discharge, that's interesting. What is an absolute discharge, and where does it rank alongside other crimes? Well, I've got it up here on the British government's website. The lowest level punishment you can be given is a conditional caution. That's essentially bail conditions, but kind of, you're sort of given a piece of paper, kind of restraining order sort of thing, where it says, here is the civil punishment, no need for the court, the police give you the punishment, kind of on the spot punishment. So conditional caution, and that's spent as soon as it's issued. That means you don't have to declare it after it's issued. It goes a more formal caution, a police warning, that's also spent as soon as it's given. A disqualification from a disqualification, that's more put for driving, and that is spent after the disqualification has ended. On to absolute discharge. When applying to go abroad or applying for a job, you have to declare the absolute discharge for up to 6 months after you are given it. Now, absolute discharge, of course, a minor version of a conditional discharge. A conditional discharge, roughly the same thing, but with more conditions in place. More common with terms like binding over and supervision orders. That's spent after 1 year. 1 year after the order is made. Because then we're on to things more suitable for youth offenders. If you're a youth offender and you're sentenced to a detention of no more than 6 months, it's spent after 3 years. Hospital order spent after 5 years. Probation order for someone under 18 will spent after 2 years. If you're an adult and you're on probation, spent after 5 years. Young offender sent to a detention centre for more than 6 months but less than 2 years, spent after 5 years. If you're given a fine, whether an adult or a young person, you don't have to clear after 5 years. If you're given detention in respect of a conviction for service disciplinary proceeding, if you're in the army, for instance, spent after 5 years. It's interesting how the youth system and the army system are all mixed up with the criminal justice system. If you're a young offender and you're sent to the youth offending institution for more than 6 months, you declare it for up to 7 years after it's been given to you. Dismissed from the army, you have to declare that after 7 years. Hard to imagine being dismissed from the army is a criminal offence. No, not like murder or robbery, is it? If you go to prison for 6 months or less, then you have to declare it for 7 years. Now, Borstal, I know that to be a proper prison facility. If you're sent for Borstal training, then you have to declare that for 7 years. Dismissal with disgrace from the army or any other Her Majesty service, I assume that's the prison service and the police, you have to declare that for 10 years. Amazing. If you're sacked from the police, that's a criminal offence, it appears to be saying. I might stand to be corrected on this. Back to youth custody. If you're in youth custody for more than 6 months, but less than 2.5 years, you have to declare for 10 years when you're released. If you're an adult and you're imprisoned for more than 6 months but less than 2.5 years, you declare it for 10 years. And then the most serious crime of all, if you're an adult and judged for more than 2.5 years, you must declare it forever. Now, this is interesting, as I say, various levels of spent convictions. It considers if you're unfit to plea, it considers if you're a youth, it considers if you're in the army or any other service. It also considers if you are a full-on psychopathic criminal. If you are a full-on psychopathic criminal, you then become subjected to a hospital order, which then lowers the severity, but it then raises doubts as to your fitness to plea and whether you are fit to be held accountable for your actions. But I did read some time ago that this concept of spent convictions, I thought that the past government was going to be adjusting this, because I know that apparently the system in America, of course, is whether you've got a spent conviction or not. A conviction is a conviction, even though a caution is a conviction under the American system, and that then places hurdles in the way if you getting a visa to visit America, I understand the system to be. So, very fascinating, because, as I say, if you have Asperger's and autism, then no doubt crime is not something you deliberately engage in, and to be subjected to the criminal justice system by people who don't understand your problems is quite unacceptable in my opinion. And I'd be delighted to know what your views are on this issue as well. But of course that doesn't mean to say that people who have autism and Asperger's just have a license to commit crime. What I'm saying is that people with Asperger's and autism are very easily set up for crimes where they don't realise that a crime has been committed in the first place. Okay, thanks for joining me for this video blog. I hope you join me for more videos over the next few days, weeks and months. Until next time, it's bye for now. Bye bye.